I'm Gloria Valencia Weber on the Board of Directors for Legal Aid, and I have been a lifetime career attorney in Indian law. It is also what I teach, having established the first 2 Indian law certificates among the ABA accredited schools. Today, because we have some new board members, I'm going to provide a brief overview of what the history of legal services, especially this board, has been with regard to how legal services are provided to low-income Native Americans. In the board book, for those of you who have been attending our meetings, there is an article from the Michigan Bar Association at page 318 that's a very concise but very insightful telling of how Legal Services Corporation has been involved in providing services and in the very development of Indian law itself. The main concern that we have when we deal with issues in Indian law is that within the law of the United States, it is truly sui generis, that term you learned in law school and maybe at times have never quite met the body of law that fits that. It is law-based before there was a republic, before the Constitution, so tribes are sovereigns existing in political status, in nation-to-nation relationships and treaty-making before there was a constitutional republic. It is also within the Constitution. It is not a part of the traditional constitutional law of equal protection that's usually race-based. It is not race-based law. The most important right of contemporary tribes is their sovereignty, the authority to govern actors and events on their lands. Now, of course, there is protection beyond just tribes. Individual American Indians, for instance, do enjoy the protection of the anti-discrimination laws we built in this country, just as do other individuals. I'm going to show you 2 maps. One is of the United States. It's a very simple map I could find that gives you an idea of where across the United States the 573 federally recognized tribes, those in the political nation-to-nation relationship, are. It's all over the country. Look up at Maine. That's where our Pine Tree grantee deals with 3 main tribes involving Canadian crossing issues with them. We have, of course, them spread through the whole United States. We're very much heavily into the western region, the one we just finished talking about in the prior panel. So you saw how very much that commonality of big space, many tribes, and a lot of people spread out in ways that they're not in the reach of the usual resources that many of us are accustomed to. So you have these tribes in distinct culturally based forms of government. They're governments, and we have, since this board took over in 2010, made a point that when we are in Indian country, which we clearly are, think of the prior panel, think of Utah, that we try to meet with or in some way talk to the tribes in the area. When we are in a better situation and we make a trip and spend as much as a day meeting with tribes in their homeland, where they meet with their governments, their tribal judges, the attorneys, LSC-funded attorneys that practice in their tribal courts. We have a geographical tour, and of where they are, like we did with the Tulalipes in Seattle, in Washington State, in their homeland north of Seattle. We also have done that in New Mexico at Acoma Pueblo, and we end up having enjoyable hospitality, but learning much from each other. So if we take a look now at Utah, change the map. Utah, the way the tribes are scattered, in some places in 8 distinct parcels of land, it made it not possible for us to make a trip and visit on a homeland. And that is why we constructed this panel today. In looking at the tribes who have operating tribal courts, there's predominantly 2, and one of them is in the process of having a new judge. So we have instead today just 1 judge. And you can see, looking at the map, where they are spread. And look at the southeast corner. That big glob over there is the one that is Navajo territory. And that's also connected to what we heard in the prior panel today from DNA about its 4-state reach in how it provides services. And at the Uinta on the right, that is one of the largest land bases in the United States. And it is one where, because of the way the communities have spread around in Utah, it is one of the ones where special needs arise, and our panelists today will address some of those. If you look at the Goshutes, which is where Judge Jansen is the tribal court judge, it's over on the west side of Utah. In order to reach the Goshute area, you have to travel into Nevada and come in on a Nevada state highway. The Goshute area is an area among the others in Utah that were on the trails moving to the west of settlers of all different kinds. And what happened in the history of the tribes in Utah is much of the, first of all, the settler western movement and the demands for land. There's also the effect of what has happened with natural resources development, where outside non-Indian development comes in. There's also a history of land being taken by the federal government, sometimes in times of World War II or other national crisis. Critical minerals or needs have been taken, and some land in Utah was taken to create national parks. So that's part of the history for the dissembling of what were once contiguous homelands. So now let's move to the panel. This panel is one that is going to talk to you about a number of things, but one thing that's going to continuously come up as they talk about what they do in tribal courts and in state courts. Much of it is family law, and particularly focused on children. There was a handout at the table, there are some here, but also outside, where you truly see the sui generis, the unique singular type of law that Indian law is in the United States. For instance, Title 25 of the U.S. Code, as well as Title 25 of the Code of Federal Regulations, is exclusively devoted to Indian law. We have no other distinct group or even something like families in which the federal code has a complete set of volumes just focused on them. And in the handout, this is the Indian Child Welfare Act of 1978, where Congress, in its first part of the act, says in its findings that it first recognizes the special relationship between the United States, that political, historical relationship, and the Indian tribes and their members, and the federal responsibility to Indian people. And then the Congress starts listing its findings. And that federal responsibility is now called commonly Indian Trust, where to protect the tribes and their interests, the U.S. federal government has undertaken a trust relationship that is exclusive. And as you move through that handout, you see where Congress again states that the statutes, treaties, and the general course of dealing means that Congress assumes the responsibility for the protection and preservation of Indian tribes and their resources, which leads to there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children, and that the United States has a direct interest as a trustee in protecting Indian children who are members of or are eligible for membership in an Indian tribe. And then among the findings, that the states exercising their recognized jurisprudence, traditional jurisdiction that was left for family law to states, has now been curtailed by Congress because the states exercising their recognized jurisdiction over Indian child custody proceedings through administrative and judicial bodies have often failed to recognize the essential tribal relations of Indian people and the cultural and social standards prevailing in Indian communities and families, end quote. The act is long and complex and prescribes for state courts that specific areas where tribal courts have the exclusive jurisdiction, and if a proceeding starts in a state court under concurrent jurisdiction, that the state court has a duty to transfer it to the tribal court absent two exceptions, narrow exceptions. So this is going to come up in this discussion, and Judge Sheldon Spotted Elk was unable to come because of an unforeseen circumstance, which is why I'm giving you this background for what will happen in our discussion. And so I'm going to first present our two Utah Legal Services people, in the sense of Bertie Key Lopez, who began as a paralegal in 1988. She's also trained as a Navajo certified interpreter. Bertie is a member of the Dene Navajo people, and she returned to legal services in 2005 after graduating from the University of Utah School of Law. On the end of the panel is Judge Dustin O. Jansen, who is also Dene Navajo. And he is also a graduate of the University of Utah College of Law. He also has been involved in administrative law as a hearing officer in some state courts and other kinds of arrangements. He continues to renew his judicial training by continuing training at the National Judicial College in Reno, Nevada, which is where we train state and federal judges. At this point, he has completed 6 courses. He's also an assistant professor at Utah Valley University, where he teaches in American Indian Studies and mentors students. So after law school, he joined Utah Legal Services for a while, and because he is bilingual in Spanish, he also worked on their migrant farm worker project. So he's a highly versatile judge. So we're going to start with those two, and we were lucky to be able to fill a spot on the panel with Honor Keeler on my right, who is going to speak on behalf of a not LSC funded, not LSC connected, pro bono legal organization that is facing and provide issues in Utah and representing individual plaintiffs as a pro bono service. And the issues that Honor Keeler will talk about concern not just the tribes in Utah, but tribes outside of Utah who regard the Bears Ears traditional area as a critical spiritual, cultural site for them, and has led to individual lawsuits as well as larger ones. But I will address that when we get to Honor. Let us start first with Bertie. And Bertie, if you could tell us, you do work among numerous tribes in different ways in Utah, sometimes at different times in your time with Utah Legal Services. And if you could describe first which tribes you work for and what you're doing with those respective tribes.
Okay, thank you. For the state of Utah, there are 8 tribes, and out of the 8 tribes, we serve 5. Out of the 5, we have 3 tribal courts. So we go out and visit the tribal court, tribal members on reservations. We travel 3 hours to Fort Duchesne in Roosevelt, Utah. We travel to Agapah, Utah, and that's another 3 hours. We do outreach in Cedar City for the Paiute tribe of Utah. There's 3 bands. That's about a 5-hour drive. We also serve the Northwestern Band of Shoshone Nation in Brigham City, Utah, which is about an hour drive, and also serve the Skull Valley Goshute in Tooele, Utah. Most of our cases are on Tuesdays. We provide juvenile representation to juvenile delinquencies, and we also assist tribal members as far as the guardian ad litem, with the guardian ad litem cases. Normally, our daily schedule used to be that I leave the Salt Lake City at 6 o'clock in the morning, get to tribal court by 9. My docket is usually like 10 child welfare cases. Go to lunch, take a 10-minute lunch, run back to court. I may have 18, 20 juvenile delinquency cases. Try to be done by 5 and return to Salt Lake. That is our schedule. For the Goshute tribe, court is held once a month. And again, the same process. We leave Salt Lake at 6 o'clock, get to court, be in court by 9, and start our cases. There we also do juvenile child welfare representation, where we are appointed the guardian ad litem. We also do other cases, divorces, guardianship, child welfare, juvenile delinquencies, Native American probates, Indian Child Welfare Act, and any other Indian law issues. Sometimes we try to assist the tribal courts with their pro se litigants who appear throughout the day. We also try to assist them in their pro se packets. If the tribal court has these packets, we try to assist as far as first preparing the documents, preparing the instructions, and assisting tribal members.
In reading your resume and your years of work, Bertie, I saw, for instance, that at some point earlier you had worked with the Confederate Goshute tribes of the Confederated Tribes of the Goshute Reservation in helping to organize their court and their administration of the court. Could you describe that work and how that occurred?
Yes. At one point, the tribal council didn't have a judge, and we have cases backlogged. I was asked to go through the court's cases. Some of the cases were missing, and I pulled out the cases, restructured the entire court system. separating the juvenile cases, the adult cases, and the criminal and civil. Instructed the cases so that the tribal council would hire a judge. We didn't have a prosecutor either. So I was trying to organize this. I didn't have any guidance as far as setting up a tribal court system, but I managed to figure out, let's do it this way. Maybe this will work. So when they hired a judge, which is Judge Baez Nardell, who's sitting in the audience, she was very helpful. She was a DA at the time here in Salt Lake, was very helpful in helping me along the way. And then later on, they hired a prosecutor, Heather Carter Jenkins, also sitting back there. So with the two on board, things worked smooth. Then we had to go before the tribal council to allow Utah Legal Services to provide services on the reservation. Tribal council approved us, and from there we started our legal representation.
Bertie, you mentioned there was part of your work persuading the Goshen Council that legal services was going to be helpful, but also was not going to cost them money.
Yes, for the longest time, for some reason, legal services did not have their service provider out in Agapa. So when I went out there, the tribal council felt like I was there, and again, they told me their tribal members don't have any money. I said the Utah Legal Services is a free service, and we can assist tribal members. And they told me what kind of cases they have. They have cases in state court where they can't find any representation for their members. They have cases that come before the court where juveniles are not represented. And they have a trained prosecutor. That was also happening on the Ute reservation, where juveniles were not getting any representation in court.
So let's move at this point to Judge Jansen. And Judge Jansen, you're on the other end of this process.
Yes.
You're the judge having the legal services funded attorneys in your court. So tell us from your end what it is that you're doing. Now, I know that from your background, you have quite a bit of experience having been a legal services attorney at Utah Legal Services. But now you're working with the Confederated Tribes of the Goshen Reservation. And in reading your resume, I noted that you started when you were a law student as a tribal court judge. How did that start?
Yeah. So the Confederated Tribes of Goshen, they're almost fully federally funded. They're called a 638 contract tribe. And sometimes when Congress shuts down, that means the tribal employees, the whole tribe does not get paid. And if you're on contract with the tribe, you don't get paid either. And their judge that they had prior to me stepping in was a little upset that he hadn't been paid in about 3 months. And so they had, he took all the files and the gavel and made her run for it. And so the prosecutor and the tribal attorney called me, and I knew him from undergrad work. And he knew I was in law school, and he asked me to step in. And initially the idea was, can you step in and be a judge? I said, no, I'm still a law student. He goes, we're willing to overlook that. And I'm like, I don't know if I'm willing to overlook that. And but he said, just come in, we have about 5 cases, just dismiss them, and we're good until we hire a new judge. And I'm like, okay, that's it. He goes, yeah, just no more than 3 months. It went from dismissing to no more than 3 months, right? And so I said, okay. And I went in, they swore me in, I dismissed 6 cases, and the next month they called me and said, hey, we have some more cases out here. And then the next month, and then the next month, and then 6.5 years later, I said, I think I need to go. It's a small tribe, a small community. It wasn't really like that. I had worked there 6.5 years. I got to know everybody out there. It's a beautiful community. It's beautiful people. But I had the opportunity to work for the Navajo Nation, where I grew up. I grew up just on the other side of the mountain of the tribal office buildings in a place called Tohatchi, New Mexico. And so the whole point of me going to law school was to go back and serve on the Navajo Nation. So when that opportunity came, I took it.
And in terms of your returning to the Navajo Nation, you're still, as I understand it, a hearing officer in terms of the Navajo Nation Office of Hearings and Appeals, and you work on jurisdictional issues. Is that correct?
My work with the Office of Hearing and Appeals for Navajo Nation, it's much like the administrative courts in a state setting. They want to clear up the actual courtrooms, their dockets, and so they push employment cases through, TANF subsidy cases go through the Office of Hearing and Appeals, election cases, the big Chris Deschini case went through there. But I was asked to come in on contract, and they were backed up with employment cases, former employees suing for wrongful termination and or unlawful termination. And if you're an attorney out there and you want to do employment law, you're probably going to do okay, because the Navajo Nation has the most protected employees in the world, and the way their laws are written. And so they have a lot of cases. You get laid off or let go or fired, you're going to appeal, and you'll probably come before me. But it's a mixture of statutory law that's codified. It's a mixture of what the Navajo Nation calls fundamental law. It's when I graduated law school, fundamental law meant the rooted law stemming from the United States Constitution. When you go to the Navajo Nation, fundamental law is traditional law, how the Navajo people and how Navajo culture interpret justice, and they have their own way of using tribal knowledge and culture to resolve disputes, and you have to be knowledgeable in that. And if you ask me later, there's some fun cases where people not trained to represent people in the Navajo Nation will come in and have to argue Navajo fundamental law. But here in fundamental law, they just start going straight to the U.S. Constitution, and you just see the judges just start on fire there and actually yell at attorneys and no. In Navajo fundamental law, tell me what principles, what values will demonstrate your client is correct. You have to talk about just a variety of what's the tribe's traditional view on adoption, the tribe's traditional view on marriage, the tribe's traditional view on leadership. And as a hearing officer, this thing called talking it out, that's a huge thing. We even, part of our legislative branch in Navajo Nation, they have a committee called Navakiaten, which just means talk it over. And so when I have the parties introduce themselves, one of the first things I say is, have the parties had a chance to talk things over prior to hearing. And if they say no, would you like 20 minutes to do so now? And that's a regular part of my hearings. And it's probably something I've carried over into almost every jurisdiction where I work as a judge, where I ask the parties, have you talked it over? Because traditionally a lot of tribes aren't adversarial. It's about restoring harmony, it's about restoring balance. And so the tribal courts that I've worked with have always stressed the importance of that.
A clarification here that the fundamental law, and that it's described variously in different tribes and pueblos, but it is customary unwritten law. And in a number of tribes, they may have a structured mechanism for determining that. if one brings a lawsuit in the Navajo court and you are invoking fundamental law, there are a set of respected elders and people who are recognized as those who know it, and that you can then talk to them. And if you're going to use that fundamental law as part of your case, you may have them even as experts, but you must understand what's involved. And also, Navajo is among the tribes that has an organized bar and a bar exam. So it's important for the non-Indian lawyers and the Indians from the lawyers from the non-Indian world to know that. You just don't show up and say, but I'm admitted in X state, or I'm admitted in the 10th Circuit. That's not what we're talking about. At this point, Bertie and Judge Jansen, could you describe the community in the Goshen area that you both serve? What's the size of that community? How large is the population? What are the kinds of livelihoods that operate there to support families? And anything about the communities themselves?
Confederate tribes have about, at the time when I was really knowledgeable, about 550, close to 600 members living out, or at least enrolled with the tribe. Living out, there was about 50% living in the reservation, mainly because if you get on I-80 and go west, you're not going to see anything until you hit Wendover, Nevada. Now imagine turning left at Wendover, going another hour south, and there's even less there, and so there's not, employment's not, it's not available. Sometimes we can get, they'll run a hunting bucks and bulls campaign where you can hunt elk and deer, and you can work as a guide. You can get hired as a day worker and put up fences, repair potholes. But for the most part, if you're living and working out there, you're working for the tribe in their administration building, if they have a position open for you. The children out there, there is an elementary school that the tribe has, so the kids can go to school there. Prior to that, K through 12 were getting bused into Wendover, so they were traveling 120 miles round trip daily for educational purposes. But that's the clientele. A lot of older people, small rural community. A lot of the cases from adults that come in are probably alcohol related. We have juvenile cases come in, and it's just ought to be bad to have a good time. You know, how catching lyrics. You're in the middle of nowhere, and you have high school kids just wanting to have a good time, and so they'll come through our courts. And then some of them are just children in need of care. Their parents are off working in Salt Lake or Wendover or Lake Tahoe, and their kids are left with grandparents hoping to raise them. Because of the high cost of living, they can't afford to take them with them, and so they end up in our court systems too.
Bertie, in terms of the families you work with, how often do you run into questions of Indian Child Welfare Act cases that involve state law, state judges?
Not as much for Goshen, but probably a number out of the Ute tribe and the Paiute tribes. And Utah Legal Services would be in a position to represent the biological parents and not necessarily the tribal entity, because tribes usually have their own attorneys. So we would come in and try to represent the bio parents through Utah Legal Services. That's if the adoption is happening in the state of Utah. Other times, we might pick up cases from another state where the child has been removed in the state of Utah, or somebody coming to, or one of the, a pregnant mother might come to Utah just to give up a baby for adoption. So we have one case right now at the Utah Supreme Court where the argument is the jurisdictional issue right now. We're waiting for the decision.
And just to clarify, which is not on the handout on the ICWA, it is only for foster care, placement, or adoption, which involves termination of parental rights. It is not for divorce and custody disputes in divorce. So it's when biological mom and dad are not able to take care of their child, then that's where the priority of placement is in the federal statute. So we're going to shift now to a different part of what goes on in Utah. Utah is an area which has, like some of the other states, legal services organizations that are not funded by LSC, and there is a national organization of them called the Native American Indian Legal Services Group. The most probably well-known one is Native American Rights Fund. So Anna Keeler, to my right, is working with the group that is doing critical work in what, for our discussion, I'm going to call the Bears Ears historical area. This is different from what was created as the monument under prior administrations, and in the current administration has been reduced in size. There are organizations in litigation or attempting to get legislation on that, but that is not what we're talking about here. This is the Utah Diné Bikéyah, in which honor is involved, representing individuals, low-income individuals. And I need to give you some background briefly on Honor Keeler. She is a member of the Cherokee Nation of Oklahoma, very involved in their cultural preservation. And I'm honored to say that Honor was one of my top students at UNM. It's not every student whose third-year paper immediately goes into a law journal as one of the leading articles on indigenous international repatriation of tribal cultural artifacts wrongfully obtained, illegally held in museums across not just the U.S., but in Europe. Honor is a very well-known expert in this area. She's the editor of a forthcoming book, co-editor of a book called Return, Reconcile, and Recovery, and this is the Rutledge Compendium in International Repatriation. And at the Utah Tribal Diné Bikéyah, it is a grassroots organization formed by tribal elders to protect traditional knowledge and cultural landscapes. And Heather, I'm sorry, I keep going a minute. Honor has more recently been appointed to the Native American Graves and Protection and Repatriation Review Committee. That's a federal advisory committee for the U.S. National Park Service and the Department of Interior. So Honor, if you could start telling us, first of all, how do you describe your clients, these elders who have special responsibility within their tribes for what outsiders call religion, but which we know to be sacred culture?
Good afternoon, everyone. It's so good to be here, and it's so good to be on the tribal lands of the Ute people and the other folks here from Utah. I just wanted to kind of put forth a point of clarification there. Utah Diné Bikéyah is a nonprofit organization, and about 10 years ago, over a decade ago, it was formed in some capacity among elders in the 7 to 10 Native communities down in southeastern Utah to protect this region called the Bears Ears Sacred Landscape. And I think you probably, for those here in Utah, have heard a little bit about this and perhaps nationally, but That organization got together and eventually became a 501c3 and put through a proposal along with the Ute Indian tribe, Ute Mountain Ute, Zuni, Pueblo Zuni, Hopi, and Navajo Nation tribes to protect 1.9 million acres in what became the Bears Ears National Monument. When it was designated in 2016, it covered 1.35 million acres, which you can see up here on this map, which is a fairly good representation. We often say it looks like a bear with a feather or a woman holding a feather. However, about a year later, under the next presidential administration, that area was reduced by 85% under President Trump and has been separated out into the Shasha and Indian Creek units, which you can see represented up there in red. And it was at this time that those 5 tribes who had proposed the original 1.9 million acres in the Bears Ears National Monument in their litigation pod, and Utah, Diné Bikéyah, and the National Trust, and a few other people in their litigation pod, and another complaint went in, challenged that in the courts. And that became the case that's going through the court system, the district courts right now, called the Hopi Tribe versus Trump. And one of the questions that's been asked in the court and that we're challenging, of course, through our membership and through our board, who are traditional leaders and leaders in tribal communities, are whether or not Congress, we know that Congress through the Antiquities Act delegated power from Congress to the president to create the national monument. And one of the questions is, did Congress actually do this to reduce that national monument? At the same time, a few months later, the administration, through the BLM and through the U.S. Forest Service, started the environmental review process of the Shasha and Indian Creek units. And there was a very an expedited process which happened in this process, which was influenced by an order coming down from the Department of Interior. And throughout that process, there's been a finding of no adverse effect, which some of the Pueblos have opposed and UDB has opposed.
So that people understand part of what has formed this organization and the elders who formed it. Could you also briefly refer to that area where you have your litigation pod and the history of what has gone on on the Utah map at the bottom, southeast, Blandings and Monticello, and that area of Bears Cave, which has over 100 years history of excavations, taking objects from the land that are cultural objects and doing it in violation of the regulations for federal public lands and tribal lands, and what that history has been there.
Sure, I can talk a little bit, just informationally, what happened about 10 years ago in southeastern Utah. In Blanding, there was a 2-year investigation that resulted in charges of many individuals there under ARPA, the Archaeological Resources Protection Act. And as I said, there were several arrests made. This, unfortunately, a lot of the items there that have been found in homes had come from the Bears Ears region. So there's been a very long history looting that's occurring there and in the southwestern part of the United States. The Antiquities Act, for instance, 100 years ago, was passed in part to address the terrible looting that was happening on federal lands.
I'm sorry that we don't have more time because of the complexity of how the services, first on the Utah Legal Services Native American grant, are being delivered, as well as how tribal courts are interacting with our LSC-funded attorneys. But the issue that the organization Honor is with involves just about all of the tribes in Utah, plus many outside, and is continuing to be a problem that has been going on for some time. It's not usual that you have massive federal raid, as happened 10 years ago in Blanding and Monticello, going into residences to remove illegally taken cultural objects. And I thought, in terms of understanding Utah, having Honor talk to you about these people she works with and the elders who have special duty and responsibility for care of those objects, for the ceremonies at the sacred sites within their ears. This is part of an ongoing controversy in Utah that's going to take some time to resolve.
Thank you. I'd also like to add just nationally, there's some legislation that's been put forth addressing trafficking. It's called the STOP Act. And this federal piece of legislation was conceived of to help address some of these trafficking issues that have been an ongoing problem for quite some time. The work that I do, in addition to my work with Utah Diné Bikéyah, is tracking down those ancestors and cultural items that have been taken from communities and burials and sacred places and finding them all over the world. And this has happened through collectors. It's happened through these trafficking avenues. It's happened through historic exchanges of museums. And it's a very important issue for the tribes right now.
We're going to conclude the panel at this time because we need to finish, and we know we have limited time in this court building. I wish we had more time for questions, but I really feel that this has given you a picture of Utah, what happens among the tribes, what's happening with the courts that serve them, and also what is a continuing big, not just social issue, but a big individual issue for many people in Utah. And Honor Keillor was able to step in. I thank you for it.